Right now, somewhere in this country, a Social Security recipient is watching money get pulled from their account by a debt collector who has no legal right to touch it. Somewhere else, a senior just paid a stranger $200 to file paperwork the Social Security Administration processes for free. And in nursing facilities across multiple states, residents are being told they must hand over their monthly benefit as a condition of keeping their bed, a practice that federal law explicitly prohibits. None of these things are legal. All of them are happening. And the reason they keep happening to the same population, to retirees and seniors on fixed incomes, is not complicated. The people doing it are betting that you do not know what the law actually says. Today, I am going to show you exactly what it says. 5 specific deductions and charges that are illegal under federal law, who is behind them, and what you can do to stop them or get your money back. Before we get into it, subscribe now and turn on notifications for clear updates on Social Security, benefits, and important rules that could affect you. Hit subscribe and let's go through these one by one. Illegal deduction number 1. Private creditors garnishing your Social Security payment. This is the most widespread illegal charge on this list, and it affects more seniors than any other. If you have outstanding credit card debt, medical debt, personal loans, or payday loans, collection agencies will frequently send letters or make calls threatening to garnish your Social Security if you do not pay. Some of them follow through and attempt it. Here is what federal law says. Section 207 of the Social Security Act explicitly prohibits the assignment, levy, or garnishment of Social Security benefits by private creditors. Credit card companies cannot garnish your Social Security. Medical debt collectors cannot garnish your Social Security. Payday lenders cannot garnish your Social Security. The protection is absolute for private debt. The only entities that can legally collect against Social Security are the federal government for back taxes, the SSA itself for overpayment recovery, and in specific circumstances, domestic support obligations like child support or alimony. Everyone else is legally barred. If a private collector has threatened garnishment or has actually caused your bank to freeze funds that came from Social Security, contact a legal aid organization immediately. In most states, this qualifies for free legal assistance, and the collector can face federal penalties for the violation. Illegal deduction number 2. Fee collection by unlicensed Social Security application helpers. Across the country, a growing number of businesses, immigration consultants, notaries, community service offices, and online services are charging seniors fees to help them apply for Social Security benefits. These fees range from $50 to several $100s per application, and in every case where the person charging is not an attorney or an SSA-accredited representative, collecting that fee is a federal violation. Under the Social Security Act, it is a crime for any person who is not an attorney or an SSA-approved non-attorney representative to charge a fee for services related to a Social Security claim. Even attorneys and accredited representatives must have their fees reviewed and approved by the SSA before collecting. The application itself, the assistance with the application, and the guidance through the process are all available directly through the SSA at no cost. You can call the SSA at 1-800-772-1213 and receive free help filing your claim. You can also visit ssa.gov and complete the application entirely online without paying anyone for assistance. If you paid a fee to someone who was not an attorney or an approved representative to help you file for Social Security, you may be entitled to a refund, and the person who charged you may have committed a federal offense. Report it to the SSA Office of Inspector General at 1-800-269-0271. Illegal deduction number 3. Nursing facilities requiring residents to sign over their Social Security checks. This one directly targets some of the most vulnerable people in the Social Security system. Federal law under the Social Security Act prohibits nursing facilities that receive Medicaid or Medicare funding from requiring residents to assign their Social Security benefits to the facility as a condition of admission or continued residence. That means a nursing home cannot make you sign over your monthly check to get a bed or to keep the one you already have. The resident has the right to manage their own finances or to designate a representative payee of their choosing. The facility cannot appoint itself as your representative payee and then use your Social Security to cover costs without following the strict federal guidelines that govern how representative payees must handle those funds. If a nursing facility you or a family member is in has made this kind of demand, contact your state's long-term care ombudsman program. Every state has one. It is a free advocacy resource, and they handle exactly these situations. You can find your state's ombudsman by calling the Elder Care Locator at 1-800-677-1116. Illegal deduction number 4. Medicare providers balance billing you above the approved amount. If your doctor, specialist, or other healthcare provider accepts Medicare, there are strict federal rules governing what they can charge you beyond what Medicare pays. A provider who accepts Medicare as their payment for a covered service is called a participating provider. Participating providers are legally prohibited from charging you more than the Medicare-approved amount for covered services, with limited exceptions for standard deductibles and coinsurance. What many seniors do not realize is that even non-participating providers, meaning those who take Medicare but have not signed a participation agreement, are still subject to a limiting charge cap. They can charge no more than 15% above the Medicare-approved amount. If you have received a bill from a Medicare participating provider that charges you significantly above what Medicare paid and above your standard cost sharing, that excess amount may be illegal to collect. Pull the explanation of benefits from your Medicare account at medicare.gov and compare what Medicare approved and paid against what the provider is billing you for out of pocket. If the numbers do not add up, file a complaint through Medicare at 1-800-633-4227. You are entitled to a full accounting, and illegal excess charges must be refunded. Illegal deduction number 5. Banks freezing or levying your account to satisfy a creditor judgment when the funds are Social Security. This situation combines the garnishment protection from the first point with a specific banking rule that most people have never heard of and that banks are required to follow. When a creditor obtains a court judgment against you and sends that judgment to your bank, the bank is required under federal rules to automatically protect a specific amount of Social Security funds before allowing any freeze or levy to proceed. As of 2026, banks must automatically protect 2 months of your Social Security benefit, calculated based on what was deposited in the 60 days before the garnishment order arrived. The bank must do this automatically. It is not something you have to request or argue for. It is a mandatory protection. The problem is that many banks are failing to apply this rule correctly, and some are freezing the entire account or allowing the full balance to be levied, including the protected Social Security funds. If your bank froze your account and you have Social Security funds in it, contact your bank in writing immediately and reference the Treasury Department's garnishment exemption rule for federal benefit payments. If the bank fails to respond correctly, file a complaint with the Consumer Financial Protection Bureau at consumerfinance.gov or by calling 1-800-411-2372. The protection is federal law. The bank does not have discretion. Here is what all 5 of these situations have in common. In every single case, the illegal charge or deduction is continuing because the person being harmed does not know the law gives them a specific right to push back. That information gap is the entire business model for the people doing it. They are not going after people who know their rights. They are going after people who have been told or allowed to believe that they have no choice. You now know the law on all 5 of these. If a private creditor is threatening your Social Security, Section 207 of the Social Security Act protects you. If someone charged you to file a Social Security application without being an attorney or accredited representative, that fee was illegal. If a nursing facility is demanding your benefit as a condition of residence, that demand is prohibited under federal law. If a Medicare provider is charging you above the approved amount without justification, that excess billing is illegal. And if a bank froze Social Security funds that should have been protected, the Treasury's automatic protection rule applies, and the bank must correct it. Write these down. Not because you will need all of them, but because the one you need is the one that changes everything when you know it exists. Subscribe, share this video with someone you know who is on Social Security, and I will see you in the next one.